Hello everyone, hope you have an amazing day and welcome to my new blog. Today our topic is the Employees Compensation Act 2010 issues, prospects and challenges. Now, as we all know, the Employees Compensation Act 2010 is a social security welfare scheme that provides comprehensive compensation to employees who suffer from occupational diseases or certain injuries arising from accidents at workplace or in the course of employment. The basis of jurisdictions or justifications for compensation is the employer's duty of care. So, the idea of compensation suggests that someone has suffered a wrong for which he has to be compensated monetarily, and the implies that another person has a duty to prevent the occurrence of the wrong suffered. Payment of compensation by the employer to the employee is rooted in the accepted principle that the employer has a duty of care, a duty to protect the health, welfare, and safety of workers at work where the worker sustains injuries, get ill, or dies in work related circumstances. The employer is liable to pay compensation to the worker or to his dependents in the event of death. This article is intended to examine the issues, prospective and challenges of the Employees Compensation Act 2010. Now, the Employees Compensation Act 2010 is a social security welfare scheme that provides a comprehensive compensation to employees who suffer from occupational disease or sustain injuries arising from accidents. So, payment of compensation by employer to the employee is rooted in the acceptable principle that I earlier mentioned. So, the sources of the employee's duty of care. So, wherever employer worker relationship exists, whether express or implied, and if it is expressed, whether oral or in written, the employer owes certain duties to the employee. These duties may be expressly provided for in the term of a contract of employment or implied into the terms, even even though not expressly stated. Now, the source of the implied duties. The source of the implied duties of the employer to exercise care or reasonably care for the employee's health and safety are twofold, namely common law and statute. So, the employer implied duty under common law. The employer implied duty to exercise reasonable care under the common law is usually divided into three. Number one, provisions of safe plant, including safe equipment, tools, materials, and appliance in the workplace. Number two, provision of safe and secure system of work, that is a safe work process. And number three, provision of employee with reasonably competent fellow employee. So the employer implied duty of care under status. Employer also have implied duty of care under the following status and international instrument among others. So factories, these provided for compulsory registrations of factories, no overcrowding. Now, fencing of dangerous equipment, coverage of vessels containing dangerous liquids, adequate training of any person to be assigned to operate machines, safe access into the factory. The duty of care under the Factory Act is more enormous or onerous than the ordinary duty of reasonable care required by common law, and hence the courts have held that the failure of the employer to carry out the duties outlined in the Factories Act amount to negligence, which in turn attracts damages also. Now, the Labor Act. This status contains the following relevant provisions: duty to medically examined workers being recruited before commencement of work or as soon as possible thereafter, duty to provide transportations to the place of work also, and to take care of health of worker in the process. Now, protection of the health and care of women and children, particularly against night work. Now, fatal accidents law of the status. So, or states, these provide for compensation based on the amount of benefits the claimant received from the deceased person, where the death of the person was caused by wrongful act, neglect, or default of another. Now, National Environment Standard and Regulatory Enforcement Agency Act, that is NESREA, National Environment Standards and Regulatory Enforcement Agency Act, Section 270, 27, that I mean, A. So 27A, Act 2007 prohibits environmental pollutions, including discharge of hazardous substance in harmful quantity. So it should be noted, however, that this provision is weak, as the plaintiff has to prove that the quantity of discharge is harmful. Also, the same section contains a proviso suggesting that the defendant will not be liable if it can be shows that the discharge of the harmful substance is authorized under some law. Now, the Constitution or the constitutions of the Federal Republic of Nigeria, that is 1999, it provides inter alia that the state shall direct its policy towards ensuring that conditions of work are just and humane. There are adequate medical and health facilities also, and that the health, safety, and welfare of all persons are safeguarded. Now, International Labour Organizational conventions and recommendations. The following conventions are relevant to this work: Convention number 55, Occupational Safety and Health, 1981. Convention number 12, Worksman Compensation Agriculture, 1921. Conventional number 17, Worksman Compensation Accident, 1925. Convention number 18, Worksman Compensation Occupational Diseases, that is 1925. Convention number 19, Equity of Treatment Accidents Compensation, 1925. Convention number 42, Worksman Compensation Occupational Diseases Revised, 1934. Convention number 221, Employment Injury Benefits, 1964. Now, the historical origin of worksman compensation. For many years, issues relating to the welfare of the Nigerian worker have suffered neglect. In effect, Nigerian workers who sacrifice daily for the economic development of the country are left to the whims and caprices of their employers, who in most cases treat their welfare with levity. This is more pronounced with foreign companies operating in the country with over 70% of their workforce engaged as casual workers who are paid irregularly. These unfair labor practices often subject workers to inhuman conditions. So, Nigerian workers have over time labored under a dearth of social security schemes. Able bodied and employed persons have grand under the yoke of unbearable social and financial burdens also. So there has also been the plight of diseases invalid and injured employees who are ultimately released. So retrenched, repeated, right sized, downsized, outsourced, or removed from the workplace under the guise of whatever management jargon catches the fancy of employer of labor. Invalids and mentally and the physically challenged who were victims of occupational disease and workplace accidents also are usually depend on their communities, relatives and neighbors, religious groups and charity also. So workmen's compensation scheme is over a century old. As we all know, the first English workmen's legislation was 1897. Under it, the workman only needed to show he had been injured to claim compensation. In Nigeria, the first workmen's compensation legislation was the Ordinance of 1942. So prior of worksman compensation systems, work injured at work were compensated under the system of negligence and liabilities. These systems required the employee to prove the followings as I described right now. The employer has a duty of care owed to the worker. An accident has occurred. The accident was caused because the employer failed to exercise the duty of care, and the accident caused personal injury also to the employees. The principle that an employer of labor is not liable without proven negligence, it illustrated in the cause of uh, Chaguri versus Yakubu. In the case, so Yakubu was employed as a driver with a company and attached to one of the top officers of the company. So, as part of the schedule of his work, he had to take the cooks of the Saguri to their residence late in the night, and once on one of the occasions he was attacked by armed robbers who shot at his face. He was able to escape with his car. His boss Chagari rushed him to the hospital. The company paid the hospital expenses. After treatment, 5 pellets of bullet were extracted, leaving 1 pellet, which could only be extracted at the risk of serious negative health problem, though Yakubu admitted he was no longer feeling pains. He instituted legal actions claiming in 15 million, that is in 5 million as special damages and in 10 million as general damages. Now the company and Chaguri appealed to the decisions of the trial court. The court of appeal held that damages should not have been awarded against the appellant since no finding of negligence was made. Now, under the negligence liability rules of the common law, the employer enjoys the following 3 defenses and would not be liable to pay the monetary damages if any of the defenses can be proved. Defense of voluntary assumption of risks, otherwise referred to as voluntary non-fit injury, that the worker knew of the damages or risks involved in the work and willingly assumed risks by accepting the job. So this means that by accepting the job offer, the worker has abdicated the right of sue for injuries. Now, fellow servant defenses of or defense of common employment, that a fellow worker of the claimant worker caused the accident. So, contributory negligence is, however, not a complete defense in that a successful plea of same will not reduce damages. Now, contributory negligence, that the injury employee's negligence contributed to the occurrence of the accident, that the foregoing translates into is that in many cases it could not be difficult for employer to avoid liabilities also under any of the above three defenses. The situation left much to be desired, hence it become necessary over time to abolish the common law negligent liability defenses, either statutory or in judicial decisions. So the British Employer Liability Act 1880 abolished the old common law defenses in theory but did not establish a no fault system, meaning a proof of negligence on the part of the employer was still necessary for the employee to be entitled to damage. On the defense of voluntary assumption of risks, the trend of judicial decision today is that where negligence of the duty of care is proved, the employer cannot rely on the maxim of violenti non fit injury to protect him from liability for his wrong, as court had held in another case. So that's for the video, my friend. If you like my video, please subscribe my channel. Thanks a lot.